From the main list, item number 1.
Your Lordship, the conducting counsel of this case is out of station, Your Lordship.
Dr. Buzika was appearing.
Your Lordship, I am appearing on behalf of Dr. Mose, petitioners, Your Lordship. The counsel for the respondent is out of station, Your Lordship.
But usually the admission is ex parte.
Your Lordship, Dr. Mosika is on legs before court number 2. I've sent my colleague to call him, Your Lordship, if this matter.
Please speak a little louder.
Your Lordship, if this matter may be placed at the end of the board, I've sent my colleague to call Dr. Mosika. Is on legs before court number 2.
On the prayer of learned counsel for both the parties, this appeal is adjourned for the day. Monday.
Yes, Your Lordship. Much obliged.
Item number 2.
May it please your Lordship, my Lord.
Yes.
Your Lordship was kind enough on the last occasion to allow us a permission to file an additional supplementary affidavit, which was inadvertently missed out. And accordingly, we have filed it on Monday, my Lord. And a matter has come up for admission for this Honorable Court. My Lord, the whole case which hinges around is about my whole case is principle of natural justice has not been followed. That's my case, my Lord. I'll just place it. What was about the case about, my Lord?
This is an intra-court appeal.
Yes, my yes.
Please show us the judgment of the.
Yes, I'll show. My Lord, if your Lordship looks into the judgment at page 35, my Lord, there were two projects which was given to us to put a hydropower project. And there was a preliminary agreement which was executed. And in the preliminary agreement, there was an inbuilt mechanism whereby we have to achieve milestone, and if you don't follow it, then they have to issue a so-called notice, and thereafter they can take an action. Now, my Lord will kindly see. Para 8, page 42. May I read the judgment or your Lordship the operative portion?
Just give me 2 minutes.
Yes, yes, of course. Of course.
Works contract termination, whether fair or unfair, upon observance of the rules of natural justice, would be very difficult for you to maintain.
Termination without notice.
Man, our whole case is regarding termination without any notice.
At least on a cursory
Yes.
reading of the judgment, and then his lordship, termination cannot be held to be irrational, but as far as other reliefs are concerned, you are relegated to the civil.
My lord, when the matter was moved, may I just point out, termination, my lord, only the point here is the learned single judge, with great respect, my lord, has said that 19/4/2020 to when the notice 22, there is a review meeting which was called for. And that review meeting which was called for, we absolutely denied they have not called for. And a single judge, with great respect, my lord, relied on that there is a substantial compliance of a review meeting. And my lord, by way of a termination, the nature of the lease had changed. That's the observation of learned single judge. But when they terminated on 22/12/2023, my lord, termination speaks about that if you want to terminate on the basis of preliminary agreement, my lord, there is an inbuilt mechanism whereby a so cause has to be issued. And it is an admitted fact.
So that is in the contract itself.
Yes.
Usual clause in all government contract, 14 days, so cause.
No. Here, my lord, your lordship will, if your lordship permits me, my lord. Clause 4, 5, 6 of the preliminary agreement. My lord, if your lordship is not inconvenient, your lordship kindly see para 8 of the judgment, my lord. Page 42, my lord. If your lordship permits me, may I just read page 42, para 8, my lord.
But what is the arbitration clause? How many arbitrators?
There is no arbitration clause. That's the whole difficulty here. There was no arbitration clause here, my lord.
But his lordship has referred to it.
Yes, but that's so not, with great respect, that was not correct, my lord, because there is no arbitration clause. What has happened while deliberating, my lord, the matter before this court? Then there was it said, even if there is an arbitration clause, even, my lord, principle of natural relief is not followed to some judgments. But here in this case, my lord, there is no clause of arbitration.
Mr. Khan, there is no arbitration clause.
No, Lordship, admittedly is.
No arbitration clause, my lord.
Then civil suit.
Well, that's what, my lord, I am before this honorable court, my lord. Why the principle of natural justice is not followed, and why, my lord, it is not a case of specific performance of contract also. And that has been discussed by the learned single judge. If your lordship looks into it, my lord, at paragraph 8 of the learned AG argument at page 42. Kindly see page 42, my lord. Paragraph 8. If your lordship allows me just to read. The learned AG has then contended writ petition itself is not maintainable, as it is hit by delay and laches, and a matter concerned disputed question of facts and is realm of contractual jurisdiction. It is further contended, same is a terminal contract for which specific performance cannot be sought, and in support to this contention has placed reliance on the following decision. Now, 10 is important, my lord. To the mind of this court, the entire matter hinges upon the maintainability of writ petition, considering the fact that the dispute that has arisen is purely from a contractual arrangement or situation in the realm of private law. The only factor that will determine the question is whether the action of termination by the impute notice can be considered arbitrarily to the extent to warrant interference by this court in exercise of power under Article 226 of the Constitution of India. Paragraph 11 is most important, my lord. In the first writ petition, WPC 362 of 2023, the petitioner has sought withdrawal of the minutes of meeting held on 24/2022, wherein a review meeting, the decision to cancel the project was taken based on appraisal report showing that the project was technically viable but not financially viable due to high cost, and a letter dated 9/9/2022, wherein the petitioner was informed about the said decision. It is to be noted, petitioner did not attend the said meeting, though notice has been issued to them. In the second writ petition that followed, the change challenges the letter dated 22/12/2023, terminating the two preliminary agreements dated 9/5/2014. The termination order, however, invoked clause 29 of the preliminary agreement, and it is given therein that the order was being issued in accordance with preliminary agreement dated 9/5/2014. The order, in fact, had changed the complexion of the lease between the parties inasmuch as from a simple cancellation which were under review, along with other power projects which stood cancelled due to unviability or other condition, the invoke of the clauses of the preliminary agreement to the effect the same would mean that the contractual relationship or the preliminary agreement was still subsisting. Now the learned single judge dealt with the maintainability at page 53 at para 16, my lord. Sorry, para 14. Kindly see para 14, my lord, page 50. Page 50, para 14. However, the impugned termination notice dated 22/12/2023, categorically under two subject heads, has stated that describe the nature and purport of the said notice as one of the termination of the preliminary agreement dated 9/5/2014. A further perusal of the termination order would reflect that reliance has been placed for the said termination in the clauses contained in the preliminary agreement, and in the said notice itself, reference has been made to a proposal placed in the review meeting dated 19/2/2022. In the concluding part, it has been stated termination has been made in exercise of power under clause 29 of the preliminary agreement, and that the impugned order was being issued in accordance with the said agreement. Though, my lord will kindly note, though it has been argued and also reflected, termination order is a reiteration that the preliminary agreement is no longer in existence. The very fact, however, this respondent, in spite of having by letter dated 9/9/2022 conveyed this decision of cancellation, would have effectively cut short the matter. Termination order being on the basis of preliminary agreement, it stands to reason that before issuance of the same, as per clause 5, the petitioners would have been so caused and heard. This opportunity having admittedly not been extended to the petitioner, this court is therefore to finally examine as to whether termination order is arbitrary and unreasonable. Now, my lord will kindly see para 16, then page 54. Para 16, my lord, page 54, second paragraph, regarding maintainability part. Page 54, subparam. With regard to the question,
Yes.
with regard to the question of disputed facts, though this aspect has been agitated, this court on examination of material does not find this point relevant for consideration. On the issue of whether the petitioner is seeking specific performance of contract, this court is of considered view that with the issuance of termination order, which has been challenged in the second writ petition, now concern only the question as to whether the said order is unreasonable and arbitrary. This aspect has also no further relevance in this discourse, because the learned government, the AG, has argued the matter, saying that this writ petition is not maintainable. The learned single judge replied to it because the entire complex of the lease had changed because of termination of the order. So, by a flex of time, because the whole argument which was advanced at the first writ petition was, by a flex of time, the contract doesn't remain. But the learned single, the lease of the entire lease has been complex, has been changed because termination order. So, learned single judge has given a reply to the maintainability that is not so important. What we are to decide regarding about principle of natural justice has been followed or not. Now, my lord will kindly see at 19, paragraph 19, page 57, my lord. In the page 57, paragraph 19, my lord. May I, my lord? In the backdrop of the above noted cases, which have been cited by
And in the facts and circumstances of the case,
There are 19, my lord. There are 19. In the backdrop of the above years which have been cited by the parties and consideration of the facts and circumstances, apart from the points of law and principle as enumerated, the most important aspect in this is the situation of the facts of the case which are peculiar to itself. As discussed above, the preliminary agreement at clause 5 has clearly provided that due opportunity be given to the petitioner in the event that cancellation is being contemplated on the breach of condition of the preliminary agreement. No doubt, this clause has provided for an inbuilt mechanism that binds the respondent to afford an opportunity of hearing to the petitioner before cancelling the agreement, thus necessitating the adherence to the principle of natural justice. However, on the other hand, from the materials on record, it is saying in the review meeting held on 24/2022, when the feasibility of the project was under the consideration and the decision taken to cancel the agreement taken, there was no representation from the side of the petitioner. Further, by communication dated 24/7/2022 and 23/9/2023, the petitioner itself, on the decision of respondent to cancel the agreement, has raised the issue of recovery of cost expenses which has been incurred in carrying out feasibility report and sought for an amicable settlement. This fact assumes significance inasmuch as respondent by the impugned order of cancellation, though citing the preliminary agreement, have maintained order.
this order is a combined order in both the writs.
Yes.
What was the prayer in the first writ?
The first it is that 24/2022, whereby unilaterally they have cancelled, my lord, and they want to enter with some other partnership. So we came up before the court. That was the case first. So when the matter was pending, the first matter was pending, on 22/12/2023, they decided to cancel and terminate our contract. So they terminate the contract.
What was the cause of action in the first writ? They had not terminated your contract.
No. They terminated
But what was your grievance in the first writ then?
the first writ petition, because unilaterally they have cancelled. They decided to cancel. They decided to cancel unilaterally without giving a notice to me.
So that is cancellation.
Yes, but they have not terminated my contract, my lord.
What is the difference?
My lord, that's what they decided unilaterally, but they, my lord, I will show, my lord, that on 19th of February, by a flex of time, they said that automatically the contract gets extinguished by a flex of time in 2015. But actual termination has taken place, my lord, in 2023, whereby they have taken.
Their assertion that the contract was had expired by a flux of time was the subject matter of the first writ.
Yes.
You said the contract was alive.
Yes, right, my lord. Correct.
Thereafter, they tried to rescind the contract or terminate the contract.
Yes, right. That. And if your lordship looks at termination notice, which they have given to us, the additional affidavit, kindly see termination notice, my lord, where your lordship has.
There is no scope of any interim order.
No, like your lordship will admit this.
Admit year of the appeal, but
Year of the appeal.
But you have a very uphill and tall task.
I'll try to satisfy your lordship, my lord, if your lordship permits me, at the time of hearing the matter, that whether I have got a case.
Because under ordinary law, if the termination is wrongful, you have a claim to damages, loss of profit, for wrongful termination of the contract.
But, my
But
lord,
then,
yes.
what you are trying to achieve is that show cause notice, breach of national justice, not given a hearing, etc., taking recourse to administrative law principles, that if the show cause notice or the termination is stayed,
Yes.
it would amount to a specific performance of the contract, means that you would be allowed to complete the work.
My lord, my only respectful submission that your lordship will admit this and hear this matter, my lord, which is our convenient for your lordship, my lord.
Because suppose we hold that they ought to have given you a hearing, it was unfair, etc. And we say that the show cause notice is bad, honest, and we set it aside. But that will not prevent them from, in future, the very next day, to terminate the contract again.
No, that is absolutely, my lord. But at least we can get a chance, my lord, to at least, because what they said, the project technically.
And you will not be able to claim specific performance of this kind of contract.
No, we are not claiming, my lord. We don't want. We want this project to be implemented by us. Why? 2015, we have given the rates to them. 2015.
No, but you cannot compel them under the law.
No, that's my lord.
If it is the agreement for transfer of a house, immovable property, specific performance is allowed by law.
No, that's your lordship is absolutely
But for
right.
this kind of a contract, it is only in damages.
No, only breach of agreement. That is why I have come up before this court.
If you
Principle
succeed, you will get damages.
So principle of
For
natural.
whatever you have lost out of wrongful termination.
My lord, we have not claimed damages. We have just, before this honorable, to just
Allow
revamp.
you to complete the complete the project.
Yes, that's. And only principle of natural that they should give a notice, my lord. If I find that at least I have received a notice, given a reply, and if out, my lord, I'll be out.
But if they don't want you, you cannot compel them in
That's
this kind.
it's a different aspect altogether.
But if
my
they change your mind, if they change their mind, that all right, we accept the explanation, and we
Yes.
waive termination.
Yes.
And allow them to come.
Yes,
That's a different matter.
That's a different issue altogether. Your lordship is absolutely my lord.
All right, please take down. Where is the judgment of his lordship?
Lordship at page 35 it starts, my lord. 35.
This is an appeal from a judgment and order made on 5th November 2024. Made by a single judge of this court on 5th November 2024. Dismissing the writ petition on the ground that it was not maintainable. And relegating them to the private law domain. Full stop. This finding was arrived at after holding in paragraph 20 of the said judgment that it could not be said quotation, there was no substantial compliance of the principles of natural justice in cancelling the agreement, unquote. And quotation, the termination therefore cannot be held to be irrational or arbitrary. Or that the same is malafide or unreasonable, unquote. To warrant exercise of this court's writ jurisdiction. Paragraph. We admit the appeal. Paragraph. There is no scope of any interim order. Next, we propose to hear it out, dispensing with all formalities. The usual paragraph regarding filing of paper book. By when you can file your paper book?
Within 2 weeks. 2 weeks, man.
After vacation.
After vacation.
10th February?
Then.
Lordship, that bonded warehouse matters are fixed on 10th February.
No, paper book we file, but
Lordship.
for hearing on 20th February, 20.
I'm deeply obliged.
And
Deeply obliged.
have you prepared any stay application?
Yes, we have preferred. But your Lordship, on the very first instance said that because there was some interim order, to the extent that will be subject to further order of this honorable court when the matter was taken up by this court.
What is the first sentence you have written in the order? Dismissing two writ petitions. At the top of the order, you will find the numbers bracket. WP 362, WP 18 appointed. Then you write that all questions before the learned trial court, including the question of maintainability, are kept open.
Yes,
in appeal.
Yes. There was an order which was passed. In the meantime, any further action or respondent will be subject to further order of this court. While,
It is implied.
yes, deeply obliged.
Item number 3.
Deeply obliged.
So number 3, I'm praying for some accommodation well today.
Ready for hearing?
It's otherwise it's an appeal from the order of the learned single judge below.
Appearing for the first time.
My lord.
For the first time, appearing for the
No, it has come earlier. Also. The earlier respondent number 6 wanted to file an affidavit and subsequently they said they are not filing affidavit, my lord.
after vacation.
After vacation.
All right, by consent of learned counsel for the parties, This appeal is adjourned till 10th February.
Item number 4.
Well, this is also an appeal from the order of the London Single Judge, my lord. There was a delay of 176 days in filing the appeal.
My lord, I may be allowed to.
Delay of
176 days, my lord. I may be allowed to file a.
sorry,
I may be allowed to file a show cause on that delay.
affidavit.
Affidavit.
All right. Learned counsel for the respondent opposes the application for condonation of delay. Next. Let affidavits be exchanged. In that application, as according to the following direction, affidavit in opposition by February, affidavit in reply by 17th February, list the appeal and this application on 19th February.
My lord.
Item number 5.
May it please your lordships.
Yes.
Lordships, this is there's a continuation, there's a delay, lordship, of 1 day in filing of the appeal, lordship.
You take it up the application.
Lordship.
Actually, we have no objection.
You have no objection.
What is the appeal about?
Lordship, the primary contention out here, lordship, is it's in relation to Nokmaship, lordship. So there is a portion of there's an Aking, lordship, in Garo Hills that is essentially within the Raksam clan, lordship. But the issue in this appeal, lordship, is it arises out of a joint Nokmaship between two clans, which we are contesting, lordship. Lordship,
We will condone the delay, keep the appeal for admission after vacation.
Lordship,
Acha.
There is a delay of 1 day in filing the appeal. It is condoned. As there is sufficient explanation for this. We allow the application under Section 5 of the Limitation Act. We direct the registry to register the appeal and to place it before and to list it for admission. On 31st January.
right, Lordships.
On 30th January, Thursday.
Lordships.